So, hi everyone. A very good evening from my side. My name is Kumakshi and I'm your co-trainer for paralegals. In this class, we would be helping you prepare the paralegal exam for the licensing held under the LSO. This specific class focuses on the way you handle the overwhelming syllabus for the LSO paralegal licensing. So, in this 8 weeks, for different subject, we'll have different classes which are helping you cover the whole LSO material along with exam workshops and the way and the approach you have to appear in the LSO examination for the paralegal licensing. The main focus of this class would be helping you understand the basic concepts that LSO expects you before becoming a paralegal. So if anybody has scrolled through the LSO website, they have certain competencies of you becoming a paralegal and helping you understand what are the types of questions you would see. So, a basic thing that you have to adhere to is anything that is mentioned on the LSO website is actually what is the way they are testing you that you must know out of the whole syllabus. So, the core of testing you is not you should remember the 1000 page material. It is the way you handle, or maybe the way you expect the questions to appear and test your knowledge on different subjects. Getting it? Now, when I talk about the LSO materials, it is basically the material that governs 5 different subjects: professional responsibility, civil litigation, jurisdiction, and help me out with this fundamentals, then criminal law,
Admin,
and the last one,
admin.
admin law. So, when we talk about any of such programs which test us based on the 5 materials, we are technically dealing with the ways in which we have to apply our knowledge in different arenas of law. As paralegals, the best thing with us is that we are blessed to have a monetary jurisdiction these days of up to $50,000 per plaintiff and per defendant. So this means I wouldn't say per plaintiff, per defendant. I would say 50,000 for the plaintiff and 50,000 for the defendant, making the aggregate total suit value of $100,000. Now, taking an overview of whole Canada at large, these days people are going through a bit of a recession in the economy. People have less money, corporations have less money, and paralegals are the kings of the whole court structure these days. Why? The suit value of people has decreased. Paralegals have got a higher increased monetary jurisdiction value, and now they are eligible to practice on certain cases which have more value monetary jurisdiction than it was earlier. Now they roam as kings for LTB matters, small claims court, for highway tickets, for provincial offenses, for any contract related matters, for you can say even family law. If you people are aware, there's an additional examination for family law. If paralegals want to practice for the family law division, they can give additional examination having an 80 mark worth, and they can also practice in the family law section. So it is technically that barristers and solicitors, although practicing in the divisional and the higher courts, have got the similar position with the paralegals when they are practicing in the smaller courts. Because in most of the places, people who used to file cases in the divisional court earlier for the 50,000 amount, now they have come down to the small claims court because of the monetary jurisdiction. So, a huge network of cases, a wide range of cases, the paralegals experience. And that is where paralegal becomes one of the most biggest profession in Canada when it comes to the law. Even the JD does not have that much seats, whereas the paralegal seats are more in Canada. Done? Okay. Now, what would be our focus? Whenever you're attending a class with me, my class is going to be this intro class being on Sunday. But we would be switching up the time because civil litigation is a vast subject. It requires you to know the procedures. And what I want from your side is your 100% attention and your 100% mind focused on the procedural steps. And I also understand it's going to be a Sunday evening. I want you to spend time with your families. So, introductory class on Sunday, but we would be switching the regular batch to some other day for civil litigation particularly. Okay, Sunday we might have an exam workshop, an easy one, so that we can just recap in a short while, and then we can spend other time doing our other stuffs. So civil litigation is by far overwhelming. When we go to procedural subjects, always remember they're gonna be dry. This is a for sure thing. But the dry subject, if you understand with actual court procedures and actual judge in mind, this is the judge, this is the reader, this is the assessment officer sitting, what are the roles and responsibilities of those people, it can help you understand how we are dealing with these people, what is our stand, how does the other paralegal on the opposite side, on the defendant side react, what are the roles and responsibilities and stuff. Clear? So this subject is going to be more than a practical subject rather than we focus on the book or the reading materials. Clear? Okay. So with me, you would be doing your civil and then your half part of criminal law, the later end, along with some chapters which might help you understand the the concepts of other maybe jurisdiction and fundamental and the public law. Done? Okay. So I expect Sonia to not Sonia, but Sonia, maybe your camera is blank. I want Tiana to read it with me. We are doing chapter 16 for civil, chapter 22 for civil, which is called Jurisdiction and Organization of Courts of Ontario. So, let me give you a small brief of the whole thing and then it would help you understand. And I want you to draw that table for me, please. There's a table that I would showcase with hand and I want you to draw that table with me, please. So there's one CJA, Court of Justice Act. Court of Justice Act, CJA, that governs the structure and making and running of the courts in Canada. This is a federal statute, Courts of Justice Act, giving rights to the establishment, the organization and stuff for the courts in Ontario. Now, when we talk about courts in Ontario, we are technically talking about multiple facets of the courts, which can be divided in parts. The first page tells you the organization of courts under CJA and the court system available in 8 regions. So, Tiana, can you please read out the 8 regions for me?
Regions: Northwest, Northeast, East, Central East, Toronto, Central West, Central South, and then Southwest.
So this means they've divided the whole organization within Ontario into parts, into directional parts. So these are the places, 8 regions wherein you find your courts, wherein you can practice. Clear? Come to the next paragraph, please.
Paragraph right after the...
Yes.
Okay. The boundaries of the regions are fixed by designation of regions, RRO 1990, Reg 186, made under the Courts of Justice Acts, and they can be adjusted from time to time. A designated regional senior judge is responsible for administrating the judiciary within his or her region. With the exception of Toronto, the populations of the 8 regions are roughly the same size, although geographically the regions are quite different. A paralegal should be aware of the local differences when traveling outside his or her local area.
Great. So when we have written CJA, it gets divided into two parts, right? The first part is Court of Appeal for Ontario, the Court of Appeal for Ontario, and the other part is Court of Ontario. So these two divisions have been regulated by the RRO, by from the CJA to the RRO, giving the courts in the 8 given segments of the region. So you would find courts in Toronto, Northwest, Northeast, East, Central East, Central West, Central South, and Southwest. Done? 8 regions. Now, talking about what language do you consider the courts to follow? So, specifically, we have 2 official languages in Canada, 2 official languages in courts of Ontario, English and French. The normal proceeding of the documents is done in English language, but if somebody wants the documents to be translated or to be available in the French language, they can specifically request on that. Anybody who wants all the documentation to be done in the specific French language has a right to apply for a bilingual proceeding or for only French proceeding as well. So 2 official languages, in routine we use English, but if somebody wants, they can also opt for the French option or the bilingual option. Yes, go ahead, please. Read 1.1 language.
The official languages of the courts of Ontario are English and French, except as otherwise provided with respect to the use of the French language. Hearings and documents are to be in the English language, with interpretation and translation of documents as required. Pleadings or other documents filed by the party or process issued in or giving rise to the proceeding may be written in French. On a party's request, the court shall provide a translation into English or French of a pleading or other document filed by the party or of process issued in or giving rise to the proceeding. A party
Go
who
ahead, read
speaks
the whole thing.
a party who speaks French has the right to require that the matter be conducted as a bilingual proceeding. A party can exercise that the right by filing the first document from that party in French language or having the register issue the first document to be issued by that party in the French language. Made under the CJA. Alternatively, a party may file a bilingual proceeding requisition Form 1, or file a written statement that expresses a desire that the proceeding be conducted as a bilingual proceeding. Similar procedures are used for an appeal that is to be a bilingual proceeding. Bilingual proceedings are also available in French for examinations out of court. Provision for bilingual juries in specified geographic areas is also made.
Okay, all right. So what happens is most of the litigation in Canada you would have seen as practicing or maybe as citizens of Canada, that most of the litigation is in the form of a form that you fill and submit to the court. It is not the basic drafting that we used to have in our back homes, or we used to see a pile of pages. It is a form based thing, the form that you submit. So a technique to showcase your language, otherwise also it's clearly written that which language do you want the things to be. You tick mark the correct language that you want to select. But a technique of doing it is, if you are the plaintiff and you want the language to be selected in a certain way.
You're muted. You're muted.
All right.
There you
So when you opt for filing the first document, you're the plaintiff in the case, you opt for filing the first document, you can do it in the French language. Now, once you are doing it in the French language, that automatically depicts that you want the proceedings to be held in the French language itself. So what will the court do? The court will, by default, keep your file under the French language thing. Okay, but otherwise also as a general routine, you go to any court. If you see the form of that court, there's a specific option that tells you want to have the proceedings in which language. Now a bonus tip to everyone from my side: whenever in the book you find any form number, okay, so let me train you that way. You need to have three highlighters or three colored pens in your hand. One is black, one is blue, and one is red. Black one for making any notes on the side, blue one for highlighting any exception, the red one for any limitation or forms. Three forms in total. Clear? Now, whenever you see any form anywhere, you as paralegals must know, and you're already trained in your self thing as well, that you have to open the court practice of the small claims court, extract out that form, what is form number one, and read it with your eyes. So the best thing that you can do for yourself is to know which form you're talking about and where it is actually mentioned. So if I am telling you that there's the form actually contains a section which asks you which language do you want to go forward with, you yourself have to do this task. Open the form on they can be on the practice directions or on the specific course website. Open it, download it, just see with one eye that whether you find that particular thing on the thing. And trust me, in the exam, you would never forget this thing. So this is a bonus tip specifically for civil and for criminal. Wherever you find any forms, open it, remember it. Because see, why do we go for the LSO examination? LSO examination, according to me, is the best examination we can go forward. The reason, this material that we are reading, it is not only going to help you today pass the exam, but also during your actual practice. They're training you on how to proceed ahead with your career. And they're training you before giving you the license so that you don't face any difficulty. So trust me, this knowledge is not only going to be the one helping you pass the exam, but after that also. When you are actually paralegals, your licensed paralegals practicing in courts, this information is going to help you. Done? So we are going to develop our ways that way. As you know, Amir sir also says, think like a paralegal, act like a paralegal. So it is the same way. You have to act in a way you know the forms. And you're so handy with forms before even you enter the courts that you're too good with your practice. Done? Okay. Now, the third place that we divided the things into two parts: Courts of Ontario and Court of Appeal for Ontario. Court of Appeal, with the name we suggest, it is the appeals court, the highest court of appeal within the section of Ontario, within the province of Ontario. So, appeal cannot be the first instance thing. It has to go through the different level of courts first and then maybe transfer to the appeal section. So we'll study about Court of Ontario first. Now, Court of Ontario has two divisions: the Superior Court and the Ontario Court of Justice. The Superior Court of Justice, which is called the SCJ, and the Ontario Court of Justice, which is called the OCJ. Superior Court of Justice and Ontario Court of Justice. Clear?
Yes.
Now, this SCJ, very commonly known, if you people are in Brampton, the court at Ontario is the SCJ, right? SCJ has further divisions. This is the biggest court, and most of the time you would see people filing in the SCJ. Why? Because OCJ has no civil jurisdiction. The Ontario Court of Justice, OCJ, has no civil jurisdiction, right? No civil jurisdiction. Now, this SCJ is divided in four parts. SCJ is divided in four parts. First is divisional court. Second is family court. 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 Divisional
All right, what
code,
was the first one? The
divisional
first
code, family
one?
code, small claims code, and specialized code. Small claims code and specialized code. Now, why have I divided these things in such parts? What is the monetary jurisdiction of divisional code? It's going to be 50,001, 50,001 to infinity. 50,001 to infinity is divisional code's power. Why? Because 50,000, maybe till 50,000, from $1 to 50,000 comes in small claims code. Write that down. From 1 till 50,000, it comes to small claims code. Family code, as the name suggests, it is only for the family disputes. Anything related to the family law. And then we have specialized codes. They're only available in specialized region of Toronto. And they basically deal with the commercial and the estate list. The commercial and the estate list. Now, because Toronto is a hub, a business hub, we have multiple companies working, multiple, shareholders, estate trustees, and, too much stuff. So sometimes what happens is when a bulk of cases for a specific thing comes up, the government or the act CJA creates a specialized court dealing with only that particular matter, and they are the king of those particular matters. So anything that comes under the commercial list or that comes under the estate list is held with the specialized court based in Toronto region only. Clear with the monetary jurisdictions? Now, when we talk about paralegals under practice, we will specifically talk about small claims court because, as per law, we are only allowed to practice in the small claims court. Small claims means smaller matter, short matters. They are having the monetary jurisdiction of 1 till $50,000. Now, anything from 1 to $50,000 has to be dealt with by the paralegal. It might come under highway traffic, it might come under POA, it might come under LTV, it might come under maybe what else? Give me examples. It could be contract matters.
Non-payment of the card payment.
Exactly, yes. That is a contractual dispute. I agreed to pay and I did not pay. So, civil technically is a combination of contract, tort, and your evidence. Contract, tort, and evidence. When all of these three combine, they create civil litigation. Because in the litigation, we present evidences, and that evidence is based on the conduct of parties, either created by a contract, which is written, or deemed contract. What is a deemed contract? I gave you my Zoom meeting link. You joined the class. We people came into a contract as soon you joined the link. Even if we didn't have a written contract, but as soon you people join, we are under a contract. Clear? So all the disputes when it comes to civil, they are related always, you would say. It would be related to either a tort or a contract. And even some torts start with the initial contract. Clear? Done? Enjoying so far? Understood? Okay.
Yes.
Tiana, let us read from 1.2.
Court of Ontario. The Court of Ontario consists of two divisions, the Superior Court of Justice and the Ontario Court of Justice. Superior Court of Justice. The Superior Court of Justice is a superior court of both civil and criminal jurisdictions. It possesses inherent jurisdiction and has all the jurisdiction, power, and authority historically exercised by courts of common law and equity in England and Ontario. The Superior Court of Justice consists of a Chief Justice who is also its president, an Associate Chief Justice, a regional senior judge for each region, the senior judge of the family court, and such number of judges as fixed by regulation. The various administrative responsibilities of the Chief Justice are set out in Section 14. Each region has a regional senior judge who exercises the powers and performs the duties of the Chief Justice in his or her region. The Superior Court of Justice exercises original or trial jurisdiction in civil matters. Every proceeding in the Superior Court is heard and determined by one judge. In addition to its original or trial jurisdiction in civil matters, the Superior Court of Justice also has some jurisdiction in appeals. Apart from the small claims court, paralegals are not allowed to appear before the Superior Court of Justice.
All right. So what do we confer from here is SCJ deals with both civil and criminal matters. It has inherent jurisdiction. Now let us go back to the times when we people in Canada were used to ruled by the people from England, the crown. Today also we are a constitutional monarchy held by the crown, but we are going back to the times. Inherent jurisdiction means superior court can take up every sort of matter. Now, Superior Court is not a court in itself. It is divided in 4 branches. But definitely when the 4 branches start from the point of, the basic contract of parties, it has inherent jurisdiction, the first instance jurisdiction or the original jurisdiction to take up those matters. There are 3 words that we use for the SCJ which mean the same, which is inherent jurisdiction, first instance jurisdiction, and the third one, original jurisdiction. 3 words mean the same. It technically means this particular court has all the power, the initial first instance, the original power to take up any matter that has happened within Ontario. So this is, and SCJ is a federal court. You'll find SCJs in multiple provinces as well. Right? So in Ontario, anything happens, the first court that somebody has to approach to is Superior Court. Now, in the Superior Court, which branch are you actually going forward? Now, this is decided based on the monetary value of the suit. As paralegals, we must understand if the suit value is still 50,000, we can appear in that matter. If it is more than this, we are not allowed to represent. Sorry, go ahead, please. The small claims court.
Small Claims Court. The Small Claims Court is a branch of the Superior Court of Justice and is meant to provide a more accessible and less formal way of litigating disputes. The Small Claims Court has jurisdiction in actions for the payment of money or the recovery of personal property, where the amount of money or value of the property in issue does not exceed the amount prescribed by the regulation of CGA, which is currently 35,000 small claims court jurisdiction limit.
Sorry, there's a problem because you have the old materials. The current jurisdiction is 50,000. Write it with your hand, and it should be with the red pen, which is currently 50,000 for the small claims court jurisdiction and appeal limit. So the monetary value for the small claims court 2026 is $50,000.
$50,000. Okay.
This is a recent amendment, although it was applied in the last year only, but in the LSO material, it has appeared in this particular year.
Okay, so it's no longer 35,000. Okay.
Yes. Go ahead, please.
Okay. The Small Claims Court is a statutory court and does not have the inherent jurisdiction. In a case with defendant's claim, the court can hear a case with and this one's 50,000 as well?
50,000 plaintiff's claim and a 50,000 defendant's claim, thereby putting 100,000 in dispute in the small claims court.
100,000.
So 50,000 on the plaintiff's side, 50,000 on the defendant's side, total suit value of 100,000. Now,
Okay.
people come up with questions that if there are four plaintiffs, will four of them have the 50,000? No. Aggregate of 50,000 for all the defendants, aggregate of 50,000 for all the plaintiffs, total suit value less than 100,000. Okay. So let us say there's one plaintiff and there are four defendants. Plaintiff side aggregate 50,000. Defendant side aggregate 50,000. Total suit value 100,000. Okay, go ahead, please.
The court does not have a jurisdiction to try actions that exceed this monetary limit, even with the consent of the parties. However, in a case where liquidated damages were involved with both the plaintiff and defendant, each claiming 25,000, the monetary limit at the time of the dispute, the divisional court in Ontario Inc. held that it was proper for the small claims court to review the amounts claimed between the parties, and even though one party was found to be entitled to 42,000 and the other party was entitled to 21,000, the net judgment awarded of 21,000 was within the small claims court monetary jurisdiction.
This actually means that even if your claim succeeds, now this is an old case wherein the limit was 35,000 and the amount that was allowed by the court was 42,000, and that amount was denied. That person was told to go in the SCJ divisional court to get this particular amount, but the lower amount one was allowed because it was within the monetary jurisdiction. But in today's scenario, what has happened? Is this 42,000 within the limits? The answer is yes, because the monetary value has arisen to 50,000 limit. So now these days this particular case law has been ruled out. It has no relevance now. Why? Because now the small claims court has the power to allow $50,000 as compensation as the final award, and it is within the jurisdiction. Go ahead, please.
Although Section 96 of the CGA appears to preclude equitable relief in the small claims court, the Court of Appeal in Grover v. Hodgkins held that the small claims court does have jurisdiction to grant equitable relief where the amount of money or value of property in issue is within the monetary limit of the small claims court. Although not strictly before the Court of Appeal indicated that similar language in Section 97 apparently precluding declaratory relief did not deprive the small claims court of the power to grant a declaratory judgment where the amount of money or value of property in issue was within the monetary limit of the small claims court. The divisional court in Liu v. Canada Attorney General held that the small claims court could hear a suit against the federal crown that was within its monetary jurisdiction. The judicial head and president of the small claims court is the Chief Justice of Superior Court of Justice, who is responsible for assigning the judges to the court. Every judge of the Superior Court of Justice is also a judge of the small claims court. There is also a small claim. That's good.
Okay, so what do we get from here? Small claims court is one of the most fantastic courts that in your practice you would find in Canada. What is the reason? Small claims court is the only court giving people power to have a case filed against the crown as well. Why? The small claims court has two special features. Number one, it allows hearsay evidence. What is hearsay evidence? That you don't have a concrete proof. I gave Tiana $10,000. She's a good friend of mine, and we both agreed that Tiana would agree to return back this money to me within a month because she's suffering from maybe her paycheck has been declined for some reasons. She would return back that money to me. We didn't sign a formal contract, and it happens sometimes with our friends, with our colleagues, with our employers. Sometimes it is not always we are writing a formal contract and getting it signed always.
Mm-hmm.
And at the end, I do have messages, I do have WhatsApp chat with her. I have let us say Nitin sitting in front of me who saw giving money to Tiana. But Tiana refused to pay. After a month, after 2 months, after 3 months, she refused to pay. I've been asking her, begging her, I need my money back. Please give it to me. She says, what money are you talking about, Kumakshi? So that is where the hearsay evidence is no formal documentation of evidence, but based on what you've heard, what you've listened, or maybe I can also bring up those witnesses which says, yes, we heard Tiana and Kumakshi fighting over a monetary dispute, and Kumakshi was asking money and Tiana refused to pay. This is also valid evidence. Hearsay evidences are no formal evidence, no formal piece of paper or a contract submitted to the court as evidence, but witnesses telling their version or maybe heard version of facts. Number one, small claims court allows hearsay evidences. And number two, small claims court is the only court that allows you to file a suit against the federal crown. Why? Because this is the freedom that Canada gives you. Canada is a country which gives you all the freedom. When something interferes with the right of enjoyment of your life, even if crown has done that thing, they give you a right to file a suit against the federal crown, irrespective of whether you're a layman, you're fighting a suit for $1 or a $50,000. Although registering a suit with the crown has very different civil procedures in the evidence structure and the witness structure, but otherwise, now this is, a privilege given by the crown to people at large, that even if you're not happy with me, you have all the rights to sue me. So this is, the legacy of the crown that we carry in Canada. So two special features: hearsay evidence allowed, and you can sue the crown. Now, one thing that you need to highlight here is the judicial head and president of the Small Claims Court is the Chief Justice of the Superior Court of Justice, which we call CJC, Chief Justice in Canada. So, Superior Court of Justice has one person appointed as Chief Justice. He is the head of all the Small Claims Court. But on the alternate, all the judges in the courts of superior court are also the judges of the small claims court. So this means there's a building divided in, parts. The same judge is gonna hear your matter maybe in the divisional court, and one day you might also find judge sitting in the small claims court region and taking up your case, because the judges, they rotate. They don't sit in one particular place, they rotate. So one day, even in, some places where you don't have that bulk of cases, the judges appointed in that particular region, they tend to sit in other regions as well, taking up different matters. So you might find some SCJ judge taking up your small claims matter. The same judge might also sit in the divisional court. The same judge also might take up a family matter. Done? Okay, go ahead, please.
It would start from deputy.
Last paragraph. There's also a small claims court administrative judge.
There is also a small claims court administrative judge appointed pursuant to Section 87.2 of the CGA. The Chief Justice of the Superior Court of Justice may delegate to the small claims court administrative judge the Chief Justice power to direct and supervise the sittings of the small claims court and the assignment of its judicial duties. The small claims court administrative judge may also hear and determine proceedings in the small claims court. Deputy judges may also be appointed to hear and determine proceedings in the small claims court. A deputy judge is a lawyer who has been appointed by a regional senior judge of the Superior Court of Justice with approval of the Attorney General. A proceeding in the small claims court is usually heard and determined by a deputy judge. A deputy judge may be addressed as Your Honor.
Okay. So what happens here is, the first thing that you need to know is, number one, in the court we have different designations that you would find. First is the judge. Judge is superior most person that you have to deal with as paralegals. Number two is the administrative judge. Administrative judge is basically a judge that is going to handle all your matters administratively till the time you reach the trial stage. So he's gonna give you dates, he's gonna give you adjournments, he's gonna give you he's gonna entertain all your motions, and then there could be a judge who takes up your trial matters. Now, another designation that you deal with is a deputy judge. Deputy judge, in bracket, you can write a lawyer appointed by regional senior judge. So, regional senior judge sees good lawyers practicing. Now, these lawyers are barrister solicitors. Okay, so good barrister solicitor with good number of years of practice appointed by the regional senior judge. They can take up your matters in small claims court because they are smaller in nature, they are handy in nature. So these deputy judges can also take up your trials. Because the workload of these small claims court is so bulky, everybody rushes to the small claims and files a suit these days. So if you appoint, that number of judges in Ontario, it's going to be a hectic for the government as well. So what they do is, out of the lawyers only, they select and they, give them a designation of a deputy judge. You address them as your honor, but they can take up your matter. They can even determine your matter, hear and determine your matter. This means they can also take up the trial. Now, another designation that you have to deal with is the court registrar. The court registrar. Now, what powers do a registrar has? He has the power of registering that matter. He has the power to give you adjournment, the decision of the date. He has the power to, issue process. He has the power to maybe note the person in default. Okay, so if any party is defaulting, he is the watchman of the whole process, that it goes in the right way. If you people have practiced in your back homes, or you would have seen the structure, I will typically talk about India, Pakistan, South Asia side. So in courts, we used to have readers. Mr. Nitin, do you agree with it? We had a reader sitting on the left
Yes.
hand side of the judge.
Yes.
That person is technically the registrar. All the duties what a reader used to do, same duties the registrar does. Done? Okay. And then the last one is the assessment officer. Assessment officer technically decides on the monetary value of the suit, the tax, the aggregate along with the legal costs and stuff. So he's basically assessment officer. He assesses the values of the suits. And then there could be multiple clerks, there could be, copy agency, there could be multiple other people as well. Right? So this is the whole structure that you have to deal with in the small claims court. Yes, go ahead, please, Tiana.
Clerks, registrars, and other administrative officials are appointed under Part 3 of the Public Service of Ontario Act 2006. Clerks of the Small Claims Court have authority to sign a default judgment where a defendant has been noted in default, and to make certain specified orders on consent rules of the Small Claims Court.
Highlight this thing. Now, who's the clerk of the small claims court? It is the registrar. Now, registrar and the clerk, one and the same thing. He has the power to sign a default judgment. What is a default judgment? One party has filed a suit, the other party is not appearing. Once the evidence from the plaintiff has been rendered, a default judgment can be signed by a registrar. This is the huge power of small claims court. Highlight this thing and then move ahead. Yes, please.
Okay. The Small Claims Court has a statutory mandate to hear and determine in a summary way all questions of law and fact, and may make such order as is considered just and agreeable to good conscience. To ensure that To ensure that the court meets this mandate, Section 27 relaxes the rules of evidence and empowers the court to admit any oral testimony and any document or other thing so long as the evidence is relevant to the subject matter of the proceeding. This is despite the common law prohibition against hearsay evidence. However, under Section 27(3), the court will not admit testimony, documents, or other things that would otherwise be inadmissible by reason of any privilege under the law of evidence. Example, lawyer-client, or public interest privilege, or that are inadmissible by any statute. In general, the rules govern the procedure of the court. In accordance with their scope of practice, paralegals may appear before the small claims court.
Okay, so I told you earlier also, all the rules of evidence law is what we see in the civil procedure. In evidence law, certain documents are admissible, certain documents are inadmissible. Inadmissible documents that you cannot bring them on record even if you have it at hand. So those rules do apply in the small claims court also, but irrespective, you can bring up hearsay evidences which is not allowed in other branches of the SCJ, but you can bring those things in the small claims court. Clear? Done? Good with small claims court, everyone? Because this is the technical court where you are actually going to practice when you get licensed. So every small bit you must know about the small claims court. Let's move up to the divisional court. So one day a client comes to you and he tells, let us say I am coming to Tiana and I tell her that I have my dispute. The landlord has not, has confiscated my things, my jewelry, and he has locked up the door and it values for almost like $70,000. Tiana, you as paralegal, can you take up my matter?
Yes. No.
No. Why no?
We're not allowed to act in the divisional court.
Okay. And why divisional court?
It exceeds the cost, I believe.
Okay, so what is the monetary jurisdiction? Why does it exceed?
Because it's over. I don't know the exact amount. I'm not sure. So it's over the 50,000 or it's over the 3,500?
Yes. No, it is over 50,000, and this is the reason I cannot take up, you as paralegal cannot take up my matter. Because my suit value from the side of plaintiff is $70,000. Although the monetary jurisdiction is within the bracket of 100,000, but plaintiff alone cannot take the advantage of taking up or consuming up the whole value. It has to be less than $50,000. Clear? Done?
Yes.
Okay. Now, moving to the other part here, you must know that when we are practicing in the small claims court, we need to be certain with the quantitative value of our suit before we file. Although we would be taking up this question uh, afterwards in the later chapters, but the preliminary thing after we are done with identification, verification of for the client and stuff that we do in the PR, the first thing that you should have in your mind is whether am I eligible to take up this particular matter in the court. The reason, if in case the matter exceeds the monetary jurisdiction, you are not allowed to practice. Therefore, you cannot take up that matter as a client. Okay, so first thing to ascertain for yourself in the back of your head, not to the clerk, it is the monetary jurisdiction of the thing. Now, Tiana has brought up a factor which says 3,500 or something. Now, that 3,500 is basically small claims court has given you an order already, wherein you or the other party has been fined to give, let us say, $35,005 to the opposite party. Now, $3,505 is beyond 3,500, and now this can be a form of appeal in the divisional court from the small claims court. But again, since paralegals are not allowed to take up appeals in the divisional court, you only have power to the first instance trial. Okay, so even if the appeal value is anything less than 3500, you cannot appeal in the civil courts. Anything more than 3500, that means $3501, you have a right to appeal that decision in the divisional court. But because paralegals are not allowed to practice in the divisional court, that has nothing to do with the paralegal syllabus. Clear?
Yes.
Done. So whenever you're judging the monetary value of a suit, never decide on the appeal value. Just get it out of your mind. Because if you're not allowed to practice, they won't test you on those bases. But yes, they can give you a question based on it, that somebody has to appeal. Can you take up that matter? The answer is clearly no. Because the appeals go to the divisional court. That is where we get a question that small claims court the SCJ has inherent jurisdiction. The divisional court has appellate jurisdiction as well. What is appellate jurisdiction? To entertain appeals. Right? Now, in the small claims court, this says small claims court has been formed under a regulation. It does not have inherent jurisdiction. And if a court does not have inherent jurisdiction, it never could have the appellate jurisdiction. Clear? Done?
Yes.
Okay, let's come to point number B, divisional court.
Divisional court. The divisional court is a branch of the Superior Court of Justice. It is a statutory court that exercises appellate jurisdiction pursuant to Section 19 of the CGA. Under Section 31, an appeal lies to the divisional court from a final order of the small claims court in an action for the payment of money in excess of $3,500, excluding costs,
So
or the recovery.
It is changed to 5,000. Instead of 3,500, it is changed to 5,000, excluding cost.
Okay. Excluding costs or recovery for possession of a personal property exceeding 5,000 as well for this one.
Yes, exceeding 5,000 in value. No appeal is permitted from an order that is not final or where the amount does not meet the minimum requirement. So any appeal less than $5,000 will not be entertained, and if it is more than $5,000, go to the divisional court and file an appeal. Because divisional court has the appellate jurisdiction for any order that has been passed by the small claims court. Go ahead, please.
In addition to its appellate functions, the divisional court also exercises original jurisdiction in applications for judicial review of an administrative actions pursuant to Section 6(1) of the Judicial Review Procedure Act. The Chief Justice of Superior Court of Justice is the Chief Justice and President of the Divisional Court. Although every judge of the Superior Court of Justice is also a judge of the Divisional Court, in practice, Superior Court judges rotate through the Divisional Court from time to time as the Chief Justice designates. An appeal to the Divisional Court must be heard in the region in which the order appealed from was made, unless the parties agree otherwise or the Chief Justice of the Superior Court of Justice orders otherwise because it is necessary to do so in the interest of the justice. Any other proceeding in the divisional court, such as judicial review, where it exercises original jurisdiction, may be brought in any region. A paralegal is not permitted to appear before the divisional court.
So technically, it is the court of first instance and appellate jurisdiction, the divisional court. Only barrister solicitors can practice in this court. It has power to deal with the judicial reviews as well. What is a judicial review? Let us say CRA, IRCC, LTB. They're all administrative tribunals. If they've given certain decisions and they're final in nature, the person has exhausted all remedies, he can go and file for a judicial review, that the court must review the action based on two certain grounds, correctness and reasonableness. And this is the Wavell of judgment. So reasonableness is the court will tell to the LTB or the specific tribunal to be more reasonable in judging that person's case. And what is correctness? Correctness is when the administrative tribunal has done a palpable and overriding error in judging that person's matter or not adhering to what the law says or the statute says or something, in that case, based on the six grounds of rebuttal, they say that now court is going to handle this matter at the room. So the decision of the administrative tribunal gets quashed, and now the court gives a fresh judgment, and that is applicable on the person. For a paralegal's knowledge, this information is enough that in the judicial review we have two grounds. One is reasonableness, one is correctness. Reasonableness, the tribunal is said to be more reasonable in judging that person's case, and in correctness, the court takes the matter in its own hands. Now the court will deal with this matter as it was filed in the court itself. Done? And the best part, paralegals do not need to know much about it because it is not where they practice. Okay, go with OCJ. OCJ has no civil jurisdiction. So any civil dispute, what is a civil dispute? Dealing with property, contract, or tort. No civil dispute is going to go with the OCJ. This is a criminal or a provincial court handling family division, never a civil division. Go ahead, please.
The Ontario Court of Justice has as its head and president of Chief Justice of the Ontario Court of Justice. The court has a regional senior judge for each region. The court also includes the Associate Chief of Justice and the Associate Chief Justice, Coordinator of Justices of the Peace, regional senior judges, the Senior Advisory Family Judge, provincial judges as appointed under Section 42, and provincial judges who were assigned to the former provincial court, criminal division, or the provincial court family division. The Chief Justice is responsible for directing and supervising the sittings of the court and the assignment of its judicial duties. The Chief Justice must assign every judge of the Ontario Court of Justice to a region and may reassign judges from one region to another as required. Each regional senior justice exercises the powers of the Chief Justice in his or her region. Judges of this court exercise the powers and perform the duties that any act of the Parliament of Canada confers on a provincial court judge when sitting in the Ontario Court of Justice. This court is a statutory court. The judges also perform any function assigned to them or by under inter alia, the Provincial Offences Act, POA, or any other statute. This court is also a youth justice court for the purposes of the Youth Criminal Justice Act. Every proceeding in the Ontario Court of Justice is heard and determined by one judge. A justice of the peace may preside over the Ontario Court of Justice in a proceeding under the POA, except for proceedings under the Criminal Code or the POA if no provision is made concerning an appeal from an order of Ontario Court of Justice. The appeal lies to the Superior Court of Justice. Paralegals may appear before the Ontario Court of Justice.
Go ahead, please complete this one.
Only in proceedings as provided under Section 6 of Bylaw 4, made under the Law Society Act, which includes POA matters and a number of prescribed offenses heard in summary conviction court under the Criminal Code. Paralegals may not, however, represent youth in proceedings governed by the Youth Criminal Justice Act. More information permitted of scope practice found in Chapter 1.
Okay. So OCJ, I told you, has no civil jurisdiction. Now coming to the criminal part. In criminal law, we have POA, Provincial Offences Act, which the courts have given paralegals power to represent on. If the POA matter on a summary conviction has been taken up by the OCJ, we do as paralegals have power to represent ourselves in the OCJ. Now it could be after the arraignment. It could be, what are summary convictions? But the person does agree to what has come forward. He pleads not guilty, and then there's no much of evidences and stuff that has to come in. The things are already pre-set up. Paralegals can represent in those matters. So POA, Provincial Offences Act, would be studying these legislation in detail as well in your syllabus, but as a part of criminal law practice, we are allowed to appear before the OC. That's more than enough for this paragraph. Okay. Then we have specialized court. Go ahead with this, please.
Specialized courts. As part of the trend towards greater efficiency in the civil justice system in Ontario, specialized procedures have been developed and adopted for particular types of proceedings in the Toronto region. These procedures have been put in place by the means of practice directions, which are directives issued by the court providing for specific procedures to be followed. To date, specialized courts have been developed in Toronto for commercial estates and family law matters. These courts are outside the paralegal scope of practice.
Okay, so specialized court, I told you there are two lists, commercial list and estate list. It is only based in Toronto. Why? Because Toronto is a big commercial hub. So any business disputes, any estate disputes, they didn't want the other courts to be bothered by that particular thing, or the Toronto court specifically to be so overwhelmed with the workload. They've made specialized court to handle these specific type of matter, because in most of the cases in commercial and estate list, you would find rule 77 rule things applied, which is case management. There's hundreds of parties and hundreds of defendants fighting with each other, having cross claims with each other, fighting. Somebody has to take money from someone, and someone's money has been stopped by the third party, and it's all, it's an intermingled thread. So they don't want the normal courts to practice all that, uh, you know, stubborn things. They've given it to the specialized court, and it is only based in Toronto region. So if somebody in Windsor faces these issues, he cannot go to the Ontario or Toronto region. He has to file that particular matter in the Windsor region only, although even if there's no specialized court. The specialized court is there for only on the Toronto region. Clear? Done. Okay. Now this was all about the structure of courts of Ontario. Courts of Ontario, 4 courts. In the SCJ, we have divisional court, family court, small claims court, and specialized court. And we are the kings of small claims court. And the alternate was the OCJ. In the OCJ, we can only represent in POA matters, Provincial Offences Act. On the other side, if we see, we have Court of Appeal for Ontario. I told you, whenever there has to be an appeal lied from the decision of the small claims, it goes to the divisional court. Now, what happens if divisional court has given you some order, you want to appeal that order? Now, for the purpose of appealing that order, the highest court in Ontario for the appeals is Court of Appeal for Ontario. It entertains all the appeals arising out of the SCJ or the OCJ. And again, are the paralegals allowed to practice? The answer is no. We do not have power to represent in the Court of Appeal for Ontario. It is only the barristers and the solicitors that practice there. Go ahead with 1.3, please. Tiana, if you'll feel tired, do tell me. I'll tell somebody else to read along.
Okay, no worries. The Court of Appeal has the jurisdiction that is expressly conferred upon by the CGA and other statutes. In the exercise of its jurisdiction, the Court of Appeal also has all the powers that were historically exercised by the Court of Appeal for Ontario. This is often referred to as inherent jurisdiction, since it arises from historical precedent and does not depend on statutory enactment. The Chief Justice of Ontario is the president of the court and has general supervision and direction over the sittings of the Court of Appeal and the assignment of the judicial duties of the court. In addition to the Chief Justice, the CGA provides for an Associate Chief Justice and 14 other judges to constitute the Court of Appeal. The number of judges may be increased by regulation. The Chief Justice of Ontario, with the concerns of the Chief Justice of Superior Court of Justice, may assign a judge of the Superior Court of Justice to perform the work of a judge of the Court of Appeal. The Court of Appeal exercises the general appellate jurisdiction of the Superior Court of Justice under Section 6 of the CJA. Proceedings in the Court of Appeal are heard and determined by by not fewer than 3 judges sitting together and always by an uneven number of judges. A paralegal may not appear before the Court of Appeal.
Okay, thank you. And with this, we end our first chapter. So we have learned what is the structure of courts, what are the people or the designation of clerks that we have to deal with. We learned where a paralegal can represent a matter, where a paralegal cannot represent a matter. We have learned what is the basic court structure of Ontario. How do different courts take up different matters and who heads that particular court? Are we clear with the whole first chapter?
Yes.
Yes. Is it with everyone? So Christiana Carty says 50,000 more than I haven't got full message from your side.
No,
Okay, so
sorry. At the point when you asked a question, when you were telling Tiana that it increased from
okay,
35, so that's when I typed that.
okay. All right.
Very
So
informative. Thank you.
no worries. How did you find it? Are there any questions coming up in your mind?
Oh no,
Any
it's pretty clear. It's pretty clear because you explain it very well, and I totally understand. I do appreciate it.
great. For every other person in the class, are we clear with the jurisdiction, the court structure, where a paralegal can represent, where they cannot represent? Are we clear with these things? Yes. Now see, this is how we conduct the class for civil litigation. We although would be doing the next chapter as well. I'm giving you 2 minutes to relax your minds, come out of the sphere of this first chapter, and then we'll be moving ahead to the other one. This is the exact way we would be doing the paralegal syllabus. Wherein, if you've read it once in the class and you're listening to the recording again, you're good to go with the syllabus. Whole of these 8 weeks, we are going to arrange the syllabus in a way wherein we are understanding the core of it. And trust me, I have been uh, maybe blessed to have the reviews that for civil section, be it barrister solicitor, be it paralegal, the people say that we didn't need to open our books. So this is the best review that we have got. The civil is going to be the largest section on which you would be tested. And trust me, if you're not opening the book for the civil section specifically, you're saving yourself more than 40 minutes. And 40 minutes is a lot when you're giving the exam. Right? So for civil, you would be on a hands-on practice if you're doing the course with me. 100%. Because I'm going to teach you civil in a way which you're not even going to forget when you're actually practicing. And literally, you're going to thank me when you get licensed that we do remember the concepts even today and we're using it in the courts. Okay? All right. I'm giving you 5 minutes to relax yourself. Come back in 5 minutes, have water or something, and we'll start with another chapter, which is chapter 23.
I was also going to ask a question. Do you think it would be beneficial, with what you just told us, to make kind of like a chart maybe and like have it like between like both of them, like Superior Court of Justice on one side and the Ontario Court of Justice, and kind of like write down little points of each? Do you think that would be like beneficial of like main points?
You can go ahead with it, but the only things that I've told you with the hand gestures, no, if you make that one, it will be more than good.
Okay.
You don't need extra practice. See, this is an open book examination. You don't
Mm-hmm.
actually have to, show to the examiner that I know everything. It
Mm-hmm.
is the MCQ based thing. If it is in your head, the examiner does get it. But it should be, with a flash of eyesight. So when you're revising your material, without going to the context of the book, if you see the table and you know what is there in the chapter, you're very good with the syllabus.
Okay. Yeah, this is
Okay?
the one part of the test that I found the last time I took it, that this was one of the chapters that I didn't do well in because I got very confused of like where appeals went to and where I could and couldn't act. So this is very informative. I just need to
No problem.
remember it.
This time, when you're writing the examination, you won't feel things tough because this is how, if we cover the whole syllabus, in the exam, you'll feel familiar with most of the concepts that you have at hand. Okay? Yeah, all right.
Okay.
Take your time, everybody. 4 minutes left. Come back in 4 minutes. Okay, yes. Is everyone back? All right. What about others?
There you go.
All right. Now we are going to start with the next chapter, which is chapter 23, paralegal client relationship. Now, a fun fact of this relationship is, how do you get in touch with your client? It is the client rushes to your office. Hi, paralegal, I have this particular problem with me. You're bound by the confidentiality clause. You have certain um, professional responsibilities to follow once the client comes, sit in, and tells you your confidential information. You're bound with it. And then there's, exchange of consideration. What is a consideration? The money between you and the client. You agree on certain fees, and that is the pure and the sweetest, and maybe what the paralegals actually expect to be the relationship with the client. But this relationship is not about only the confidential information or the exchange of money or the fees. It is also about certain protocols that we have to follow during this relationship, right? So when we are talking about the paralegal client relationship, we are technically dealing with the authority to act. I came into your office. My matter is just 2 days ahead. It's on trial, let us say on a highway traffic ticket. I tell you the whole scenario. You tell me the fee, and I tell you, okay, let me consider it and then move ahead. Now, you as paralegal are troubled by the fact that if I don't represent that day, I might end up in a jail. I might have a big penalty on me. And on the day of the trial, even if I've not paid you, you appear and you present my case. Are you allowed to do it? You did it out of courtesy, out of your human nature, out of your maybe sincere help for me. But can you do that? The answer is no. If I have not given you the authority to represent me, you cannot represent me. You would be held personally liable for that thing. Even if you would have done it out of courtesy, even if you would have done it out of your basic human nature or out of sympathy to me, without caring about your fee, without caring about anything, but until I've given you express authority to represent my case, you cannot come forward and take up my matter. Clear? Done? Okay. LSO punishes any such behavior if you represent as lawyer or as paralegal any client without having express authority to act. And when you have to take that authority, that is a kind of contractual relationship that you're going to have with the party. And then we have the rules of a valid contract. The party must be mentally available, they must have the capacity to come in a contract, right? They must be over the age of 18 years. Otherwise, the person who's a litigation guardian or who is a guardian of that particular person or a representative of that particular person will give you authority. Then the contract must be taken up when the person is of a sound mind, and it must be clearly communicated. The essentials of a valid contract comes in, right? So authority, but that authority also, since authority is a contract, we sign the retainer of a paralegal. Retainer is what? It is a kind of contract with that person. So the rules of contract also come into play. So we are at chapter 23, paralegal client relationship. Let us start reading from point number 1.
Introduction. This chapter introduces certain principles of the paralegal-client relationship as it relates to civil litigation and the rules of the small claims court. Do you want me to go into like 2 as well?
Yes.
A paralegal must have the client's authority to act on the client's behalf. For example, the paralegal needs the client's authority to start or continue the various steps in a proceeding. The paralegal's authority will be outlined in the retainer, and the client will provide instructions to the paralegal during the litigation process. If a paralegal has acted without authority, the paralegal may be liable in an action for damages for breach of warranty of authority.
Yes. So what is the
Actually,
breach of warranty for authority? You have to underline these 4 words. When you would be held liable, you would be held liable under breach of warranty for authority. The client didn't warrant the authority on which you acted. So you breached the warranty of authority. This is the action, and you could be held liable for all the damages that a client might suffer, and you would be personally liable as well. Clear? Okay. Now, once a person signs a retainer, he comes in a contractual relationship with the paralegal. In the contractual relationship, while giving you authority, the very basic thing is the person must have capacity to give you that authority. Capacity could be mental capacity could be the age capacity could be, are you the correct person to give the authority? Now we have 2 segments here. One is individual cases and one is corporation cases. In individual cases, it has to be the person with authority, with the capacity to give you authority. It could be my case, it could be my child's case. If it has to be my child case, I should be the guardian of that particular child. I should have mental capacity. I should be sane of mind. I should not be insane while giving you authority. I should not have any mental capacity issues. Plus, there's also a concept of bankruptcy. I'll explain it to you later on. The other segment deals with corporation. Corporation, which is artificial entity. That's not a living human being. So in artificial entities, we have different set of people having different roles and responsibilities within the corporation. Within those roles and responsibilities, there's certain designation that has authority to command for any litigation. It could be the legal head, it could be the director, it could be the board of directors, it could be any. But as a paralegal, you should be confirmed the one you're taking authority from is not the receptionist. It has to be the director, the sound person with the sound capacity to give you authority. So 2 things here, individual and the corporation. Individual, you must see the person is sane enough, and in the corporation, the person actually holds authority to give you any sort of authorization. Right? Go ahead with 3.1.
the paralegal must ensure that the client has the mental capacity to retain and instruct the paralegal. It should be noted that a client's capacity to instruct can change during the course of the retainer, such as through a progressive loss of mental capacity or as a result of an injury. Rule 3.0213 of the Paralegal Rules of Conduct, Paralegal Rules provides that if a client's ability to make decisions is impaired because of a minority, mental disability, or some other reason, the paralegal shall, as far as reasonably possible, maintain a normal professional relationship with that client. If a client no longer has the legal capacity to manage his or her legal affairs, the paralegal shall take such steps as are appropriate to have a lawfully authorized representative appointed. A client whose ability to make decisions is impaired may also be a party under disability as defined in the rules. For further information, Chapter 29, where concerns about capacity to instruct are present, the paralegal may wish to seek legal advice as the law in this area is complex.
Okay, so this means that when it is an individual having, giving you consent, you must see if the person is not under disability. 3 types of disabilities: mentally absent, absentee, and minor. A minor cannot give you authority. It has to be some representative or a guardian. A mentally incapable person cannot give you, Any authority? Why? Because it has to be represented by some maybe litigation guardian or maybe some PGT. And then the third one is absentee. Somebody whose whereabouts are not known. If that person is not known, anybody who's appointed on that person's behalf must have authority to give you further authorization. Otherwise, not allowed. And if any such thing happens, you as a paralegal have to take the adequate steps. Correct? Now, second part comes as corporation. 3.2, please.
3.2. Generally, a plaintiff who is an undischarged bankrupt cannot start a claim in his own name. There are exceptions, such as where the claim is for damages for wrongful dismissal or is personal in nature. Example for pain and suffering or mental distress. If the client is a corporation, the paralegal must be satisfied that the company is incorporated and that the paralegal's retainer is authorized. Where the litigation is in the ordinary course of the corporation's business, the paralegal may generally accept instructions from an authorized officer or an authorized employee of the corporate plaintiff without the corporation's board of directors having to pass a resolution expressly authorizing the litigation. If an agent representing a principal retains the paralegal must ensure that the agent has his or her principal's authorization to do so. Similarly, a paralegal retained by trustees to represent an estate must ensure that he or she has the authorization of all the trustees to act. Paralegals must be especially careful in situations where an individual dies after the litigation is commenced. The paralegal-client relationship no longer exists, and the paralegal may only continue acting if the estate, through the legal representative, authorize the paralegal to do so.
Okay, now two things to understand here. Number one, retainer dies with the client, right? Retainer dies with the client. So if somebody signed a retainer with you, he's dead, even though it is the court date, you can simply go ahead with the courtroom, tell the judge that the person has died, I've not got further authorization, the matter will be rested until you have been granted further permission to act by the authorized person. It could be a state trustee, it could be a representative or the legal LR. We call as legal representative. This is the first thing that you need to do. Second thing is about undischarged bankrupt. Who is a bankrupt? Somebody who claims I don't have enough money to satisfy my debts. Undischarged is he has judgments in his name. So a bankrupt, basically, what does he do? He's not entitled to give somebody any money that he is debted off. But the law also stops him that if you're not paying further, you also cannot collect. It is not like you're not paying further and then you're putting suits to collect your money and then you get enriched. It's not like that. If you're declaring bankruptcy, neither you have to take nor you have to give. But does filing a bankruptcy take up all your charter rights from you? The answer is no. The government cannot stop you. Even though you did something wrong in your business, you were a bankrupt, doesn't take away your right to life. Doesn't take away your Section 7. So if you have been wrongfully dismissed from your job, or you're suffering some claims of pain, mental harassment, or any mental distress, you can go forward because that is your personal nature kind of claims. And you can go ahead with filing such claims even if you're an undischarged bankrupt. So technically, undischarged bankrupt is not going to file for any money taking or money giving thing, but for the enjoyment of his life, if he's doing something if he's facing any problem, it is not an absolute ban on him to go to the courts. No, he can go, but for his personal things including wrongful dismissal. Maybe after the bankruptcy, he goes and finds a job for himself, he starts working, he's been wrongfully dismissed, he can go and file a suit because the wrongful dismissal from the employment is enjoyment of his personal life, not from the business or whatever he did earlier for which he was considered as a bankrupt. Second is for any pain, any insurance claim, any injury that he has got, any mental distress he has got, he can file a suit. It's not like he cannot claim from the insurance company also, because he's a bankrupt. He took insurance for this purpose, that if something happens, if he suffers any injury, he has to take that claim from the insurance company. Getting it? So, in the authority thing, individual and corporation. And in the corporation also, two specific cases. One is the bankrupt, the other one is retainer dies with the client. Done? Okay. Start with point number 4, communicating with the client. As a general rule, what happens is, when you have the paralegal at hand for the opposite party and you're also the paralegal, the communication has to be done between the paralegals. But sometimes what happens is, the opposite party is self-represented. Then you talk directly to the opposite party. But before even taking up your own party, you must guide your party throughout that litigation is going to be expensive. It's going to take time. You need to set up priorities. You need to set up the client's goals. What do they actually want from this particular litigation? And that is what you convey and communicate to the client. Okay? Go ahead with point number 4, please.
The paralegal must communicate to the client that the litigation is very expensive, time-consuming, and stressful. Before commencing a proceeding, the paralegal must understand the client's interests, priorities, and desired outcomes. For example, does the client have a long-standing business relationship with the person he or she proposes to sue, and does the client prefer to continue this business relationship? The answers to these questions will inform the paralegal's advice. The paralegal must explain that the litigation process does not start with a plaintiff's claim and end with a trial. There are also several steps before filing the claim, steps before the trial, if there is one, and steps after the trial. For example, the client may instruct the paralegal to take steps to know a defendant in default pursuant to R11 of the rules if a defense is not filed. If a defense is filed, the client may instruct the paralegal to take steps to file a motion, R15, or to make an offer to settle R14.
So it is not just the trial that has to be conducted by a paralegal. The paralegal moves motions. It requests the court to note in default, and many tactics of winning the case. It's not only the trial. Many small things that you do in civil to win the case. And it is because of either the administrative reasons of the opposite party, or maybe sometimes, the things going in your favor. Done? We will read through them once we do the other chapters. But for the purpose of this, communication to the client has to be done in a way wherein you're guiding your client. It is not just the trial that has to be done. It has to be a major kind of, all-step lawsuit. I'll take all necessary steps required for you to win this case. But under the professional responsibility, you cannot assure your client that you are going to win the case. You're just representing the client. Done?
Yes.
Now, as a continuous duty, be it a barrister solicitor, be it a paralegal, is promoting mediation whenever possible. So promoting ADR, that if there's any single room for the parties to mediate between themselves without the court being involved, you have to promote that step. So you should, as a paralegal, encourage compromises, settlements, and alternative routes rather than going to the court. Please read point number 5.
Encourage compromise or settlement and awareness of ADR. All paralegals have a duty pursuant to R3.0211 of the paralegal rules to encourage a client to compromise or settle a dispute when it is possible or reasonable basis to discourage a client from commencing or continuing useless proceedings. Pursuant to R3.0212 of the paralegal rules, paralegals shall consider the use of alternative dispute resolution, ADR, when appropriate, and inform their clients of the availability of ADR options. Since ADR is mandatory in some areas of practice, requesting an evaluative mediation can save time and money by encouraging settlement. The mediator will discuss the pros and cons of each party's case and may opine on the likelihood of an outcome.
So what happens is ADR, we have 3 things arbitration, mediation, negotiation, it could be litigation, many others. So that is number one, cost effective. Number two, see, this is small claims. And it is in 90% of the cases in civil, you would see the matters are not about money, they are about the fixed egos of the parties. If that is resolved on table, the matters do get resolved. So, as paralegals, as lawyers, we must promote ADR in a way parties come to a single point and resolve the matter, because that would be less expensive, it will save the time of the court, and as paralegals it will promote that both of the parties have won. Neither of the party loses when it comes to ADR, because half of the way the one party walks in, the half of the way the other party walks in, and both win the cases, right? So it is advisable, it is a professional duty of a paralegal to promote ADR whenever possible. Right? Last part of the chapter says withdrawal of service. When do you withdraw the service? Although there are no strict rules on how do you withdraw the service, but there has to be a motion filed by a party to for the removal of a paralegal. Or else the alternative way is when a retainer dies. If you've not been warranted again for the authority, it is automatically withdrawal of service. Okay? So, for a removal of a paralegal, a motion has to be filed in the court that we want, the party files that particular motion that we want to remove this paralegal from record, and we want to have either self-represented person come forward or some other paralegal coming forward. Please go to point number 6.
Withdrawal of a paralegal is not addressed in the rules. However, Rule 1504 of the Rules of Civil Procedure sets out the process of a paralegal could follow to bring a motion for removal as a paralegal of record, which should only be pursued by the paralegal after the paralegal's professional requirements under Rule 3.08 of the paralegal rules have been satisfied.
Okay. So with this, we end this chapter again. Are you good with this chapter?
Yeah.
And trust me, this is going to be the biggest tested chapter in your civil section, because civil is going to be mixed with the PR. And PR starts with the civil from this chapter, the paralegal client relationship. Do we remember the whole structure of both of the chapters? Starting with CJA, 2 courts, Courts of Ontario, Court of Appeal for Ontario. In the Courts of Ontario, we have 2 further courts, SCJ with civil and criminal jurisdiction, and OCJ with no civil jurisdiction but a criminal jurisdiction. In the SCJ, we have 4 branches. Number 1, divisional court. Anything more than 50,000 till infinity goes to the divisional court. We have family court dealing with the family section. We have small claims court. Anything from 1 to 50,000 goes into the small claims court for plaintiff side. Same way, defendant side also 50 till 50,000. Total suit value of 100,000. And fourth, we have specialized court only in Toronto dealing with commercial and estate list. On the alternate, we are not allowed to practice in any court apart from the small claims court in the SCJ. In the OCJ has criminal and family jurisdiction. In criminal jurisdiction, we are only as paralegals allowed to practice in the POA, summary convictions, Provincial Offences Act, summary conviction. Then, when we jot down the whole structure, we know who is the head of what thing. 2 special features of small claims court. Number 1, hearsay evidences are allowed. Number 2,
Federal Crown.
we can sue the federal crown. This is the only court wherein we can register a case against the federal crown. And that is how we learn the jurisdiction of the courts. Coming to chapter 23, it is about authority and the valid contract. Retainer is a contract with the parties. Number 1, a paralegal must have authority. If you don't have authority and you've acted, you have done a breach of warranty of authority. And if it has to be the valid contract thing, it has to be 2 ways. One is individual giving you a capacity retainer, that he has all the capacity and he is giving you due authorization. And in the corporation, the person with the good designation to give you that authority has given you authorization. Two special cases. One is retainer dies with the client. The other one is the undischarged bankrupt. Undischarged bankrupt cannot sue for other things but for personal life enjoyment, wrongful dismissal, and injury, pain, any mental distress. Then you come up with promoting ADR whenever possible. And number two, withdrawal of a paralegal by the way of motion. Done? Good with both of the chapters?
Yes.
Did you enjoy this session?
Yes.
Yes. So this is exactly the way we are going to do civil. With this, I end the class. We'll meet the next time with a new schedule of the regular classes. This was a free introductory session. I hope you like this session. If anybody wants to enroll, we are taking up enrollments for the July session. You can reach us out with Amir sir or me. You can have my number +91 700 945 1185, or you can also text Amir sir or me alternatively for your enrollments. Thank you
And what
so
is
much,
that?
everyone. It was a one. Please
Sorry,
go
I
ahead.
have a question. What is that in like for personal one-on-one classes, or are you guys having like
No,
another
no,
class?
it's gonna be a group class only, the same way we had it today.
Okay, okay. Is it a separate one from this one or the same one?
The same one.
It's a separate one? Same one. Okay.
No, it is the same one. But since these are the free introductory sessions, we're taking up enrollments now. So anybody who wants to join the regular batch, we are more than welcome to entertain that person now. You've already seen Mr. Ami teaching. You've already
Yeah.
seen me teaching. We both would be taking the paralegal batch. So you're
Okay.
more than welcome to contact us anytime for your enrollments.
Okay. I'll definitely do
Okay.
that.
All right. Any questions so far with anyone?
Can I ask one more question about judicial review? Can you go over
Please.
that one more time? Because I wasn't understanding that with judicial
Okay.
review.
What is a judicial review? Judiciary reviews the decision of an administrative tribunal. What is an administrative tribunal? It could be CRA, IRCC, LTB. It could be any. Now, a tribunal is giving you a decision which you don't like, or maybe is not taken on appropriate grounds. They've not given you an opportunity to be heard or engage a paralegal for representing you, or they've not admitted your evidences. In such cases, you want to file a review of the decision, that review it, view and then review. Review
Okay.
is done by the way of judicial review. Judicial review is taken up by the divisional court. The judiciary has two valid options there as an outcome. Number one, send it back for rehearing and telling the tribunal to be more reasonable this time. That you take this person more reasonably now. The other one is, now I will decide on this matter. I will not entertain. That is a kind of appeal thing. Similar structure with appeal, but it is under correctness of judicial review. That the tribunal has done an error in applying the law in a correct way. So let the court now take it in its own hand and apply the law and give a new decision.
Okay. And is this only for administrative tribunals?
Yes, it is for administrative tribunals, because if it is by the court, it has to follow the appeal structure. But if it
Okay.
is a tribunal giving a decision, it has to go under judicial review.
Yeah. Okay.
Okay?
Okay.
Yes,
Thank you.
Christiana.
Yeah, I just want to apologize. As soon as you're ready to start chapter 23, my Wi-Fi went down and it cut off. I've been trying to get back on and I could not get on until now. As I
No
notice
problem
you're
at all.
closing.
This session is going to be recorded. You'll have access to the recordings and you can watch the session again.
Appreciate that. Thank you so much.
All
Thank
right.
you.
Thank you so much, everyone. It was a wonderful session. Hope to see you again in the next week with new chapters. I'll be indicating the schedule very soon. And all the very best for your preparation. I hope everybody joins our regular session. In case somebody has any queries, you can reach me out. And if anybody doesn't join our sessions, we are even more than helpful and we are more than obliged if you reach out to us for any of your queries. Thank you so much. With this, I end the session. Take
Thank you
care.
so much.
Bye-bye. Have a very
Bye.
good night.
You too.